We often treat the First Amendment as a blank check, a guarantee that we can say, print, or protest anything without consequence. But the law has always set limits. Under totalitarian regimes, the press serves the state, and even a private meeting in a family home can trigger an immediate government investigation. The First Amendment exists to block that kind of control. But what happens when the right to a free press threatens national security, or when the right to assemble threatens the safety of a neighborhood? These are the points of impact where the legal system must step in and decide which right takes priority in a democratic collision. One of the most severe interventions is a concept called prior restraint. This is where officials block information from being published in the first place. The supreme test of prior restraint arrived in 1971. A former Pentagon employee leaked a secret government report detailing ongoing military operations in Vietnam. The government sued to stop the press from publishing the report, arguing that these stolen, classified documents put the immediate national security of the country at risk. The New York Times countered. They argued the public had a right to know government officials had been lying about the war. The Supreme Court ruled in favor of the press, declaring that hiding embarrassing information is not a valid excuse for censorship. To legally stop publication, the government would have to prove the release would cause certain, serious, and irreparable harm. As Justice Hugo Black wrote in the decision, the purpose of a free press is to serve the governed, not the governors. Sometimes the First Amendment crashes into another part of the Constitution, the Sixth Amendment's right to a fair trial. Take the 1976 Nebraska Press Association case. A judge issued a gag order banning the news media from reporting on an upcoming murder trial, fearing the coverage would bias the local jury pool. The Supreme Court struck that gag order down. They ruled that a judge cannot mute reporters simply because it makes managing the trial easier. To protect competing rights, the legal system has to find internal solutions. Instead of censoring the public, the judge could sequester the jury, physically keeping them away from the media for the duration of the trial. This tension extends to the freedom of assembly. Citizens have the right to gather and show unity in public spaces. This right faced a stress test in the late 1970s when the American Nazi Party announced a rally in Skokie, Illinois, a town home to a large population of Holocaust survivors. To block the hateful march, city officials required the group to secure a $350,000 permit bond. They cited the threat of violence and the severe emotional trauma it would cause residents. The court sided with the demonstrators. They determined that the expensive bond was an attempt to restrict speech specifically because of its message. The law allows the government to enforce neutral time, place, and manner restrictions, like stopping a loud protest from blocking a hospital entrance, but it prohibits content-based restrictions. The government's role is to maintain public order for everyone neutrally, without choosing which specific ideologies get the right to gather. When the founders wrote the First Amendment, the press consisted of physical pamphlets run through heavy machinery. Assembly meant physically walking to a town square. Now, digital networks can spread a message or gather a crowd in the time it once took to ink a single page of a newspaper. How can a judge guarantee an unbiased jury today when raw video of a crime scene has already gone globally viral before a trial even begins? How do local governments manage safe parade permits when a massive, spontaneous assembly can be organized on social media in a matter of minutes? And who exactly counts as the press? Are anonymous bloggers posting defamatory comments entitled to the same protections as traditional investigative reporters? Because the world evolves, the courts must constantly reevaluate these difficult cases, ensuring that constitutional protections remain effective as the tools we use to speak and assemble continue to change.